subscribe the channel and hit the bell to not miss any update. MC Mehta versus Kamal Nath. It was a landmark case in Indian environmental law perspective. In this case, the Supreme Court of India held that the public trust doctrine applied in India apart from establishing the principle of exemplary damages and the polluter pay principle. Facts of the case. In 1990, Span Motors Private Limited, owners of Span Resorts, started a new business by the name Span Club. The club was built by taking possession of large areas of land, which also included substantial amount of forest land. Ministry of Environment and Forest of the Government of India, by a letter dated 24th of November 1993, addressed to the Secretary of Forest of Government of Himachal Pradesh, conveyed its prior approval for leasing Span Motors Private Limited around 27 bighas of additional forest land adjoining to the land already on lease with the motel. Kamal Nath, the then Minister of Environment and Forest, and his family had direct links to Span Motors, and he was responsible for regularizing and leasing out the land of the company in 1994. Possession of additional forest land caused disturbance to the natural environment and thus caused swelling of the river Bees. Then the river Bees changed its course, which resulted into washing away Span Club along with the adjoining areas. Thereafter, the Span Resorts management used bulldozers and earth movers to change the course of the river by artificial means. These activities by the management caused a massive flood in 1995 and destroyed property worth around 105 crores. The Supreme Court suo motu took cognizance of the case based on article published in Indian Express. In 1996, the Supreme Court passed a judgment. The prior approval granted by the Government of India, Ministry of Environment and Forest, and the lease deed in favor of the motel were cancelled. Secondly, the Himachal Pradesh government was directed to take over the area and restore to its original natural conditions. The motel to pay compensation by way of cost for the restitution of the environment and ecology of the area. The pollution caused by various constructions made by the motel in the riverbed and the banks on the river Bees to be removed and reversed. Supreme Court ordered the motel to not to discharge untreated waste into the river. It was directed that the Himachal Pradesh Pollution Control Board to inspect the pollution control treatment plants set up by the motel. If the waste discharged by the motel is not conforming to the prescribed standards, action in accordance with law be taken against the motel. The Himachal Pradesh Pollution Control Board shall not permit the discharge of untreated waste into the river Bees. The board shall inspect all the hotels, institutions in Kullu Manali area, and in case any of them are discharging untreated waste into the river, the board shall take action in accordance with law. Supreme Court also recognized the public trust doctrine. According to the public trust doctrine, the state is the trustee of all natural resources which are by nature meant for public use and enjoyment. Public at large is the beneficiary of the seashore, running waters, airs, forest, and ecologically fragile lands. The state as a trustee is under legal duty to protect the natural resources. These resources meant for public use cannot be converted into private ownership. These resources are not to be frittered away and exhausted by one generation. Every generation owes a duty to all succeeding generations to develop and conserve the natural resources of the nation in the best possible way. The case, which was decided by the court by its judgment in 1996, was brought before the court again on 1998 for determination of the quantum of fine for pollution. Question of law involved in this case was regarding the extent of the responsibility of the polluter, quantum of pollution fine, and the nature of damages they are expected to pay. The court in its judgment held that harm to the environment amounted to threatening fundamental rights as guaranteed by the Constitution. Therefore, the damages or compensation are not only to restore the environment but to compensate the victims of the pollution as well. Any disturbance to the basic environment elements which are necessary for life, namely air, water, and soil, would be hazardous to life within the meaning of Article 21 of the Constitution. It means that environmental pollution violates fundamental rights provided under Article 21 of the Constitution. In the matter of enforcement of rights under Article 21 of the Constitution, Court has given effect to fundamental rights under Article 14 and 21 of the Constitution and has held that if those rights are violated by disturbing the environment, Court can award damages not only for the restoration of the ecological balance but for the victims who have suffered due to that disturbance. The court in this case established the principle of exemplary damages and polluter pay principle. Exemplary damages means the person who has caused pollution to the environment will be ordered to pay, which is to be so huge that it will set an example. If any person cause harm to the environment, they would have to pay amount to such a large extent. And polluter pays principle means the person who pollutes, the polluter will be ordered to pay so that the environment can be restored to its previous condition. In this regard, Supreme Court said, pollution is a civil wrong. By its very nature, it is a tort committed against the community as a whole. A person, therefore, who is guilty of causing pollution has to pay damages for restoration of the environment and ecology. He has also to pay damages to those who have suffered loss on account of the act of the offender. The powers of this court under Article 32 are not restrictive, and it can award damages in a PIL or a writ petition, as has been held in a series of decisions. In addition to damages aforesaid, the person guilty of causing pollution can also be held liable to pay exemplary damages so that it may act as a deterrent for others not to cause pollution in any manner. A fine of rupees 10 lakh was imposed on spent models in the form of exemplary damages. Thank you so much for giving me your valuable time. Do thumbs up. If you have any doubts, do let me know and I'll try in the best possible way to clear the doubts. And do subscribe the channel and hit the bell as I'll be posting regularly such law content. Till then, I'm Ricky signing off.